Good day, everyone. I'm Jirin Grace Cuizon, and today I will be discussing to you the case of Loyola Grand Villas Homeowners Association Inc. versus the Court of Appeals. Before I will be presenting the facts of this case, let me just give a brief background on what the case is all about. The case of Loyola Grand Villas Homeowners Association Inc. versus Court of Appeals, it revolves around the question of whether the failure to file corporate bylaws within the required period results in the automatic dissolution of the homeowners association. In this case, let me just present the doctrine and the relevant provision that was discussed. As to the doctrine, it says that the importance of the bylaws to corporate existence compels such meaning, for as decreed the bylaws is the government of the corporation. So therefore, indeed, how can the corporation do any lawful act as such without bylaws? Surely no law is indeed to create chaos. Thus, failure to file the bylaws does not automatically operate to dissolve a corporation, but is now considered only a ground for such dissolution. So the important provision also that was discussed in this case is under Section 46 of the Corporation Code, which is the adoption of bylaws and states that every corporation formed under this code must, within 1 month after receipt of official notice of the issuance of a certificate of incorporation by the Securities and Exchange Commission, adopt a code of bylaws for its government not inconsistent with this code. For the facts of this case, Loyola Grand Villas Homeowners Association South Inc. was organized on February 8, 1983 as the registered sole homeowners association for Loyola Grand Villas with the Home Financing Corporation, which later on became the Home Insurance Guarantee Corporation, or the HIGC. However, due for some reason, the association was not able to file its corporate bylaws in the prescribed date as stated in the Corporation Code under Section 46, which states that every corporation formed under this code must, within 1 month after receipt of official notice of the issuance of its certificate of incorporation by SEC, adopt a code bylaws for its government not inconsistent with this code. Sometime in 1988, the officers of the Loyola Grand tried to register its bylaws. However, they failed to do so. So, to their consternation, they discovered that there were two other organizations within the subdivisions. First, there is a Loyola Grand Villa Homeowners Association North and a Loyola Grand Villa Home Association South, which is headed by a non-resident and the owner of the developer respectively. In 1989, when Sullivan inquired about the status of the registration, so the head of the legal department of the HIGC informed them that their registration had been automatically dissolved for two reasons. First reason is that it did not submit its bylaws within the period required by the Corporation Code, and second is that there was non-user of corporate charter because HIGC had not received any report on the association activities. So because of these developments, it prompted the officers of the Loyola Grand to lodge a complaint with the HIGC. So by the way, HIGC is a quasi-judicial body which has the power to revoke or rescind the certificates which is granted to the homeowners. They question the revocation of the Loyola Grand's certificate of registration without due since it is without due notice and hearing, and concomitantly prayed for the cancellation of the North and South associations by reason of the earlier issuance of a certificate of registration in favor of the LGBHAI. So the HIGC ruled that the Loyola Grand obtained a favorable ruling recognizing them as the duly registered and existing homeowners association and declare the North and South associations as revoked or cancelled among others. So I agree by this. The they elevated the case to the Court of Appeals. However, the Court of Appeals affirmed the HIGC's decision, ruling that the failure to file bylaws does not result in automatic dissolution and that the HIGC has the authority to order a referendum to determine the representative of the association. So the South Association then filed a petition for review on certiorari with the Supreme Court, raising the issue of whether the failure to file bylaws within the required period results in automatic dissolution. The South Association further argued that the word must in the relevant provision of the corporate code implies an imperative act and noncompliance would result in self-extinction of the corporation. So, the sole issue that was raised on this case is that whether or not failure by the Loyola Grande to file its bylaws within the period prescribed by Section 46 of the Corporation Code had the effect of automatically dissolving the said corporation. So, in this case, the court ruled that no, Section 46 reveals the legislative intent to attach a directory and not mandatory meaning for the word must in the first sentence thereof. So the second paragraph of the law, which allows the filing of bylaws even prior to incorporation. So this provision in the same section of the code rules out mandatory compliance with the requirement of filing the bylaws within 1 month after receipt of official notice of the issuance of its certificate of incorporation by SEC. So, it necessarily follows that failure to file the bylaws within that period does not imply the demise of the corporation. So, furthermore, there can be no automatic corporate dissolution simply because the incorporators failed to abide by the required filing of bylaws embodied in Section 46 of the Corporation Code. So, the incorporators must be given the chance to explain their neglect or omission and remedy the same. Therefore, non filing of the bylaws will not result in automatic dissolution of the corporation. So that's all for the case of Loyola Grand Corporation Inc. versus Court of Appeals. Thank you for listening.